Hello, my name is Robert Goodwin, and this is Law on the Line. I would like to welcome my guest for this episode, Raul Minar. Raul is an attorney with the law firm of Minar and Minar, located two offices, one in New Brunswick and the other in Freehold. And Raul works with his slightly older sister, Paula Minar, and Raul has been a practicing attorney in the area of family law since 2006. Well, welcome aboard, Raul, to Law on the Line.
Thank you, Bob. Thank you for having me tonight. It's a pleasure.
Absolutely. And so tonight we're focusing on a topic known as the FD calendar,
Right.
and which is a calendar that our courts here in New Jersey, our family courts, have established to handle certain types of cases.
Correct.
So, what is the FD calendar, and what kind of cases does it handle?
Well, as you mentioned, Bob, the family court has assigned different codes for different types of cases. One common, when you think of family court, you might think divorce. Okay, well, divorce is being assigned the FM docket. The FD docket is assigned to the types of cases that do not involve divorce, but involves addresses issues of custody, child support. It could be health insurance. It could be also relocation, college contribution. Also, I don't know if I mentioned custody and visitation. Now, any of that type of cases can be addressed under the FD docket without divorce, because divorce is out for the FM docket. Now, married persons, if they're married and could be separated, they could file a complaint and initiate a case under the FD docket if they have a dispute over child support or custody or parenting time, but that case will not address a dissolution of their marriage if that's what they wanted to do.
A divorce, in other
Correct.
words. So this is basically a court that addresses a lot of family issues without a divorce being involved.
Correct.
One of the things that the FD calendar is known for and designed for are a pretty quick turnaround. It described that, and what does it mean when you say a case is going to be disposed of in a summary manner?
So the reason why this type of case, this case is described, as you mentioned, as a summary proceeding.
Summary proceeding.
Yes. Now, summary proceedings are designed or supposed to be resolved in, as you mentioned, an expedited matter. I believe that it's supposed to be within 90 days. Now, how often does that happen? Very rarely. Not only because of the volume of cases that our courts have to handle, but also because sometimes the issue being resolved is a complex issue that there's not enough information, or there's not enough 90 days is not enough time to really study and address, like child custody, for example. But a summary, but the reason why it's called a summary proceeding is because it was the intention that if this is not involving divorce, this is involving an issue, like a specific issue, like, for example, child support, it should be done in an expedited matter in a summary proceeding. But it doesn't necessarily mean that it's going to get done in 90 days.
Right. So just for our general audience, how does one initiate an FD complaint?
So you...
Typically, if you're not using an attorney.
Correct. So in the court's website or in the courthouse, there's forms, and you start by filing an FD verified complaint. There are the forms in the courthouse and at the website, and that's how you start it. You have to file the verified complaint, and there's other forms that have to accompany it, but it's all basically you have to file the court forms.
Is there a filing fee?
Yes. The filing fee, don't quote me, don't hold me on this, but I believe is $35 or $50. I'm not 100% sure, but it's much less than a divorce. A divorce is $300.
And one can find that all out on the website, because fees change as time goes on.
Correct. There was a time where there wasn't even a fee, I believe, for the FD docket, but then a couple of years ago, fees were instituted, much lower, though, as I said, as a divorce, and that information can be on the at the court's website. But also, once you have filled out the paperwork, You can also file, bring it in person to file it to the courthouse, and then they will tell you what the filing fee is.
And meaning bringing it to the intake office, for example, in Middlesex County, we could bring it to the intake office and they'll file it. And I assume that's in every county.
Correct. In every county, usually the family division has its own intake office. In Middlesex County, right now, Middlesex County is a little different in that the family division has its own courthouse. Right now, most of it's closed because of flooding that happened over the summer. But once it's reopened, fully operational, all family-related matters are at the family courthouse at 120 New Street.
Once the complaint is filed, what should the litigant expect in terms of notifying the other party who's responsible for that, and then a court date?
So, with regards to the court date, the court will send a notice once it has been calendared. I'll give you an example in a different county. I'm involved in a case where the verified complaint was filed in October.
Is there a docket number assigned at that time when it's filed?
Not necessarily, although it should, not necessarily, and it depends on the county. Some counties are able to assign a docket number much faster than other counties. I think it depends on staffing and volume.
Okay.
But go back to my example, in this particular case, the FD verified complaint was filed in October. We just learned that the court date is January 22nd. So that goes to my point that even though it's a summary proceeding, it doesn't necessarily get done within 60 days. One of the reasons is the volume of cases. So in this particular case, even though it's a summary proceeding, we have to wait until January 22nd for the court date. That you will find out what the court date is in the notice. As to your question of providing to the other side, it is good practice. It is not required, but it's good practice to provide a copy of whatever it is that you filed to the other side. Now, if you do not send a copy to the other side will receive a notice. The same notice that you received telling you what the date is, the other side will receive that notice. The other side will also get a form saying a complaint for divorce was filed, a complaint was filed, and it might check the issues that are addressed in the complaint, but there's not a copy provided to the other side. If the other side wants to get a copy, they have to go to the courthouse or they have to contact the court to specifically request a copy.
So you're saying the copy of the actual pleading, the complaint that was filed.
Correct.
Specifying the relief that is being sought.
Correct.
And I've been through this before.
Right.
The responding party, the defendant, they may, from the notice, only know that checked off is custody, support. It could be emancipation. It could be emancipation, college, even though that may be contradictory, or every box could be checked off.
And you have no idea what evidence or what was provided in support of whatever that is that for the request, and you don't get a copy of the request unless you ask for it. But that's why I say I believe it's good practice for the person that makes the filing to send a copy to the other side. But it's not required. Right.
And oftentimes when self-represented people go to the courthouse and they hand deliver all of the documents, they assume that everything is taken care of, and including the copy of the complaint going to the other side.
Absolutely.
I know that since COVID, we have to file that as attorneys have to file things through JEDS, or the Judicial Electronic something, D. But anyway.
Document electronic submission.
Okay, document electronic submissions.
Yeah.
Acronym politely known as JEDS.
JEDS,
okay.
Correct.
Anyway, does a self-represented person have to use JEDS, or are they able to use JEDS? How does that work?
I do not know whether they're able to use JEDS, because if you recall, in order to use JEDS, you have to log in.
And we have to have an account.
And we have to have an account. So you and I, every attorney has an account. Self-represented litigants don't have an account.
Correct.
So the self-represented litigants, I believe, are still able to physically file the paperwork. If you recall, during the shutdown, when the courthouse were closed altogether,
yes,
there was a specific Dropbox set up for self-represented litigants to file their paperwork, drop their paperwork for filing.
That is correct.
And now, once the courts are reopened, they can go to the intake office, the family division intake office, to make their filing. And to go back to your point that often self-represented persons, they believe that once they hand the paperwork, everything's taken care of. Often they don't retain a copy themselves of what
their
they
complaint.
filed.
That is correct.
So another good tip is if you file something on a self-represented basis, make a photocopy and keep a copy for yourself.
A good idea, of course. Now, you said January 26th, I think you said?
In that particular case, 22nd, January 22nd.
January 22nd. So let's
Right.
use that as the date.
Right.
Now, and let's say this is a complaint filed by a mother for child support, first time, infant child support, custody, because it's never been determined, perhaps even parentage, because the father of the child is not on a birth certificate. So you have everything that's open: the support of the custody of the child, the parentage of the child, the custody of the child, and the support of the child.
Correct.
The complaint checks off all those boxes. You have a valid address for the purported father of the child, and now it's January 22nd, 9 a.m. Firstly, are these cases held in person now, or are they done on Zoom, or is that depends upon the court?
I think it depends upon the court. I think that when it's an issue of child support, I think that it's going to be in person, and you might correct me if I'm wrong, but I think it's in person because the notice tells the litigants to bring their pay stubs,
Right. That's
in
true.
order to calculate child support. When custody is or visitation is in dispute, usually before the judge makes a determination, they are sent to mediation.
Let's do that. Let's talk about that in a second. So now it's January 22nd. We're going to use that date, Middlesex County, and we're all ordered. The parties are ordered to appear in person. You represent the complainant, which you are. You filed it, whether it be JEDS or not, because you're an attorney through JEDS. All right, 9 o'clock in the morning. What happens? Tell me what happens. Tell our audience what happens.
So you have to check in, and you're first told to bring bring pay stubs because child support is one of the issues, and child support in New Jersey is calculated using primary factors are income, amongst others, incomes of the parties. So pay stubs provides the proof of income.
And we have guidelines, and ultimately,
Correct. We have the New Jersey Child Support Guidelines, which is a computer program basically, and you plug in the factors and you get a number. You go in Middlesex County, specifically, you go to the third floor and you check in at room 301, and you're basically there for an FD. Usually it's called an FD conference.
and okay. So, in the notice, are you told about? Is the judge identified?
I think that nowadays it is identified.
Okay.
Yes.
So you know a judge, but you report to the conference room 301,
Correct.
and that's Middlesex County. But in general, you report to a conference room, and what happens?
Then usually before you see a judge, you see I think they're called a hearing officer.
Correct.
And you address what the issues are in dispute, right? And the person that filed the verified complaint is asking for A, B, C, and D, and these are the reasons why. That the other side is able to then bring up their own requests and whatnot. They try to come up with something to resolve it, and if it doesn't get resolved, nobody can force you to agree to it, or nobody can force the other side to agree to it. Then eventually it goes to the judge. Now, will the judge see you that day? It depends. It depends on the judge's calendar. But if the judge doesn't, but eventually it will go in front of the judge.
What should a litigant anticipate or expect?
The litigant needs to understand that when you get to the courthouse and when you get to see, let's say that on January 22nd, we see the hearing officer, there's no agreement, you're told to come back January 30th.
Can I just back up?
Sure.
Before the hearing officer, is anybody sworn, or you just tell your story to the hearing officer? If you have an attorney, the attorney assists you. How does that work?
Well, if you have an attorney, when you're going in the consent conference, you're not sworn. in the
Okay.
consent conference.
All right.
But if you go in front of the judge, obviously
Of
you
course.
are sworn.
But in the consent conference, does the hearing officer try to figure out the child support? Has the program?
Right.
Do they also try to figure out the primary custody? They try to figure out the parenting plan. They try to do all that.
Yes, so they try to help the parties to see if they can figure that out between themselves. Their hearing officer doesn't have the authority to make the decision, and impose that on the parties. But the hearing officer can say, well, what about this? And what about that? The hearing officer's job is to try to get them to resolve what the issue is between the parties. And if the parties are able to resolve it, then the hearing officer has, because the number of overnights is another important factor in determining the child support. Once, if the parties can get an agreement on visitation, for example, the hearing officer does have the program to calculate child support and could calculate child support. Now, let's say that there's no agreement put into place.
And before you say that, I am the defendant. I walk in and I said, now it's my opportunity. I'm here before you, hearing officer. I want custody. I want custody. I want my child to primarily live with me. Do I have to announce that before we go to court that day? Because I just was noticed to come here.
No, contrary to other types of dockets. Now, the defendant doesn't have to file anything ahead of time.
Okay.
He or she can then come to court and say what he or she wants on the day of court.
Okay. So now we can't come to an agreement because I want custody, you want custody. Maybe I'm posturing. Maybe all I want is a lot more parenting time because the mother of the child only lets me see the child from 1 to 4 every Sunday. Now we're before a judge. Okay, what? And you said we were talking about waiting, or go ahead.
Right. So you might be told to be in court at 8:30 in the morning, and you should be in court on time. However, you need to understand, or viewers need to understand that the judges have a long list of cases, on any particular day. So your case gets called whenever the judge gets to that. Now, eventually, the judge will get to your case.
I want to give a plug for attorneys. If you have an attorney, do you get to the head of the line?
Usually, if you have an attorney, yes.
What if there are attorneys on both sides now?
Yes, you get to. Usually, those cases get taken first.
And who gets taken last?
Self-represented litigants.
On both sides?
Yes.
So there is an order. So there is some advantage. I want to give a plug to attorneys, but go ahead. Go ahead. What happens?
So then the judge may make a decision even on a temporary basis, but what is usually common, what was very common, is that the judge will, tell the litigants, you need to give me a parenting plan, or you need to give me the best the custody factors analysis, because custody in New Jersey has a long list of factors. It's 17 or 14 factors. Now,
and they're statutory factors.
Statutory factors. The statute says that the judge, when making a decision regarding custody, has to analyze these factors that are listed in the statute. So sometimes the judge might very well say, I want each party to provide me the analysis. Why, each of these factors to show me why you believe, or each party believes, that custody should be awarded to him or to her. The judge might also appoint what's called a guardian ad litem, or a guardian ad litem, an expert. An expert that can do an investigation, that can do an evaluation, and then prepare a report, and now doing the statutory factors.
Is there a difference between a guardian ad litem and an expert, or?
So the guardian ad litem, yes, in the sense that the guardian ad litem could be an attorney, for example, whereas an expert, not an attorney. It's usually a forensic psychologist, somebody that's trained scientifically to evaluate persons and to conduct a report.
But Your Honor, I have no money and I can't afford an expert, and I really do want either custody, or I want 4 days a week overnight. And that's what I want. And what happens at that point? We're before the judge.
And that is a big problem that we have in our system, because often it's very common, the situation that you just point out, and the court is not going to pay for any expert. The court is not. If the court appoints a guardian ad litem or an expert, the court is not going to pay for it. It comes out of your pocket. Now, the court could then try to, at that point, to make things cheaper, it might tell the parties, do this analyze the custody factors.
And where does the person get a copy of the custody factors?
You will get in almost every courthouse that I've been in, when this issue has arisen, they give you a printout with the list of the custody factors.
Right. I've experienced the same. Right. So then you have to answer the questions and give your best reasons.
Correct. And then eventually, the court is going to have a trial on the issue of custody. And if you come to trial, you need to be prepared to, if you have persons that you believe have relevant information that the judge might want to hear, that person needs to come testify. And you need to make sure that they come testify on the day of the trial.
Of course, the parties themselves.
The parties themselves.
And you're talking about witnesses at this point.
Also, if you think that there's documents that the judge needs to look at, well, you need to make copies of it, and if possible, bring them in paper form, so that the court so you can enter them into evidence in the hearing or the trial, so then the judge can review those when he or she is making the decision.
Including photographs, et cetera.
Photographs, et cetera. It's very common that you see self-represented litigants take out a phone and says, "I have the picture." The problem with that is that the judge cannot keep the phone, for example, in the file, and then look back at the phone and look back at the picture when rendering the decision. So if you have a picture, you want to print the picture.
Right, print it out.
And bring it to you. And I would recommend too that you go to Staples, you go to a UPS store, and you print it in color, right?
Oh, good.
Because you want it to be, a lot of the times the picture loses effect
when it's black and white.
When it's black and white.
All right. What do they do about paternity? Your Honor, I'm here. I don't know anything about this child. She says it's my child. I barely know this woman.
The court will order a DNA test.
Right then and there.
Yes.
And the proof is in the pudding, correct?
Yes. And often the case, if for example, the purported father says, "I'm not the father," and it turns out that he is the father, then that person is going to be responsible for the cost of the DNA test.
And what about, when does child support begin? The judge orders after testimony, or even the hearing officer says child support is to begin and is ordered. When does the date of child support actually begin?
So the date that you make the requests. So let's say that you have
your case.
So let's say in my case it was the complaint, verified complaint. Let's say was filed. On October 31st. And we have court on January 22nd.
3 months later.
So let's say that on January 22nd, the court enters an order saying child support is going to be $100 a week, effective October 31st.
The date of the filing.
The date of the filing, not time before.
So if somebody's going to court, they should be expected to pay some arrears if there's child support that's ordered.
Yes.
Okay, it's automatic. It's paid through probation, correct?
That's the default.
Okay,
Yes.
and people can pay directly, but the default is for probation, and they keep a record, and et cetera.
Yes.
You've talked about, for example, relocation as part of the FD calendar.
Right.
We're not married. Remember, we could do this in a divorce, and I want to move even to New York, but let's use a better example. I want to move to Maryland.
Right. So
and I'm the child that resides with me.
So that's a very interesting point, Bob, because New Jersey had a change in the law fairly recent. Before the change, it was fairly easy to obtain permission to relocate out of the state of New Jersey with children. You can move anywhere. The question is the children, whether the children can go. Now, if the parties have an agreement, then the court is not going to get involved. But if there's no agreement, then the court has to make a decision. It used to be fairly easy to obtain permission from the court to relocate the children out of New Jersey. However, a couple of years ago, there was a case called Bisbing v. Bisbing, and pursuant to that case, it's a lot more difficult now. Now it's the best interest. It's the best interest. You have to show that the relocation is in the child's best interest.
I only have a couple of minutes left, but I don't have any money to hire an expert, so how do I prove best interest unless I go through the custody factors and a judge believes it is in the best interest?
It's what unfortunately that's one of the things that you have to go on. You have to go through. You have to rely on the factors. If you're objecting the relocation, the relationship is one of the issues. Is one of the factors. The distance is also one of the factors. So perhaps obtaining permission to relocate to Pennsylvania is a lot easier than to relocate to Utah.
Right.
Because the distance is also one of the factors.
I want to talk about another issue and we don't have a lot of time, but I'm a grandparent, and whether it's a marriage or not, but I'm somewhat estranged from my daughter, and I have had. I'm not talking about me personally, but I want to maintain a relationship with my granddaughter, and my daughter says, you know what? I don't want you to have anything to do with our daughter. What are my rights?
So New Jersey has what's called the grandparent visitation statute. And
you got 1 minute. Go ahead, real quick.
And that includes siblings also. You have to show that if there's no visitation, there's harm that comes to the child. If you're able to show that it will be harmful to the child not to have visitation, then it moves on to the best interest to show that you have to prove that it is in the best interest of the child to have for the child to have the visitation with the grandparent that you want.
So it sounds like almost a two-pronged test. One is you have to show that there's some harm.
And second is best interest. But you do have a statutory right. You do have the right to request it through the statute, but you have to
meet those two prongs.
Meet those two prongs.
And what if and that's very interesting. That's a relatively recent change, or has that always been the case?
So it's been a progression. In New Jersey, I believe the first statute was 1972, I believe, and it's been progressing since then. But it was more limited at the time. Back into a couple of years ago, though, the requirement for there to be harm was added fairly recently, and that's in response to a U.S. Supreme Court case that struck down a Washington State statute. Because it went overboard. Because you need to remember that there is a parent's right to custody and to make decisions of the children is a fundamental right.
But I've heard the term psychological parent. I'm the grandparent. My grandchild relies on me, and I'm really the parent, and the mother is, she's here and there. So, hither and thither, or whatever that word is.
So we have psychological parent. If you are able to prove that you're a psychological parent, then you stand on equal footing with parents with regards to custody and visitation. There's 4 elements. You have to prove 4 prongs. First, that the child lived with you. Second, that the parent fostered the relationship. It doesn't have to be explicit. It could be the mother, in your example, leaving the child with you and then going off. Second, the parent, the purported psychological parent must have assumed parental responsibilities. It doesn't have to be financial, but for example, making sure that the kids go to school or taking him to
Little League or whatever.
Mm-hmm. And third, there has to be a bond established between the child and the psychological parent, and that often requires an expert.
So at the end of the day, either you can prove it based upon your testimony and observations and your ability to articulate the issues, or you better have a good expert in your corner.
Absolutely.
Raul, I know we're out of time, and I believe we were way out of time, but I thank you so much for a very, very informative show.
Well, thank you very much for inviting me.
It was great. Thank you.
Thank you very much. Thank you.